What is New York's open container law? The moment a bottle is opened, a simple drink can turn into a legal problem. In New York, individuals often underestimate how strict open container regulations are until they are facing fines or other consequences for carrying alcohol in the wrong place. Understanding these rules is essential to safeguard your rights and avoid trouble. Legal analysis. New York's open container laws are rooted in Vehicle and Traffic Law Section 1227, which prohibits possessing or consuming alcohol in public spaces or inside motor vehicles on public highways. The statute is designed to deter drinking in public areas and reduce alcohol-related incidents. It even extends beyond alcohol. Cannabis use, burning, vaping or consuming in a vehicle on a public highway is also banned. Open container violations are typically classified as traffic infractions, but when combined with other offenses such as driving while intoxicated, DWI, they can lead to criminal charges. Direct answer. New York's open container law makes it illegal to possess or drink from an opened alcoholic beverage in public spaces, including sidewalks, parks and streets, or within the passenger area of a motor vehicle, whether the vehicle is moving or parked. The law applies equally to drivers and passengers, and local ordinances may also prohibit pedestrians from carrying open containers. Definition and process. An open container is any vessel that has been opened, has a broken seal or has had some contents removed. Bottles with broken seals, opened cans and cups containing alcohol all qualify. Possession alone constitutes a violation. Actual consumption is not required. If officers discover an open container in a vehicle, they can use it as evidence in a DWI case. The statute applies on public highways regardless of whether the vehicle is in motion, and includes passengers as well as drivers. Commercial vehicles with permits, such as limousines or buses, may allow passengers to drink, and patrons may transport a resealed bottle of wine from a restaurant if it is placed in the trunk with a dated receipt. Penalties for violations. Fines increase with each offense. First-time violators may pay up to $150, a second violation within 18 months up to $300, and a third within 18 months up to $450. Courts add mandatory surcharges, between $88 and $93, plus a $20 crime victim assistance fee. While these are civil infractions, repeat offenses or violations tied to DWI can elevate the matter to criminal charges with higher fines, longer license suspensions or even potential jail time. Who is covered and where? Drivers cannot possess or drink from open containers in the passenger area of a vehicle. Passengers are subject to the same restriction, though those riding in vehicles licensed to transport at least 10 people, like certain limousines or buses, may be exempt. Pedestrians should be aware that many municipalities ban open containers on sidewalks, parks and other public areas. Rideshare passengers generally cannot drink in standard cars, as these are treated as private vehicles. Applications for DWI and related offenses. Having an open container can support allegations of drinking while driving. Prosecutors may introduce it as evidence in a DWI case. An open container violation alongside a DWI can lead to enhanced penalties such as higher fines or mandatory education programs. Although New York decriminalized public intoxication in 1974, disruptive conduct like fighting, unreasonable noise or creating hazardous conditions can lead to disorderly conduct charges under Penal Law Section 240.20. Punishable by fines up to $250 and up to 15 days in jail. Administrative Code Section 10-125 imposes a $25 fine for possessing an open container of alcohol in public places. Avoiding violations. To comply with the law, keep all alcohol unopened and sealed. Store open or partially consumed containers in your trunk or, if your vehicle lacks a trunk, behind the last upright seat. Passengers should avoid holding alcohol during transport, even if they are not drinking. When walking, carry alcohol in sealed containers and do not drink in parks, sidewalks or other public areas. Some cities have stricter rules, so check local ordinances. Licensed establishments and events with special permits are designated spaces where alcohol consumption is permitted, but it is illegal to carry drinks outside those areas. Drinking on private property is allowed with the owner's permission. New York's open container regulations intersect with other alcohol laws. Careful compliance prevents minor infractions from escalating into more serious charges. When allegations arise, having a diligent lawyer can make a significant difference. The Kugel Law Firm's attorneys understand the nuances of open container and DWI laws and can build a strategy tailored to your situation. For help in navigating these issues, contact the Kugel Law Firm at 111 E 125th Street 2nd FL, New York, New York, 10035 or call 212-372-7218.